Well, thank you for joining us for our complimentary gathering today. We are going to cover a particular family law topic, and then we will answer some common questions that we've received over the last week to try to help you understand a little bit more about family law and give you some tips or answers to maybe some common questions that you may have as you are either contemplating a separation or divorce, or if you are already a client, or if you're already involved in the court system. So welcome. I am joined today by my team here. I have Karen Hansel. Hi. And I have Tyler Birt with me.
Hello, everybody.
And maybe if you guys just want to briefly introduce yourselves, and then we can talk about maybe a good family law topic.
Sure. My name is Tyler Birt. I am a paralegal and office manager here at the firm. I work with Aaron and handle financial aspects of particular cases, as well as running the back end of the firm itself.
Thank you. And Karen?
Hi, yes, I'm Karen Hansel. I'm the administrative assistant for the firm. I primarily interface with clients in terms of scheduling, and any kind of initial questions, probably your first point of contact to make sure you get to the right person for what you're looking for your ask. That's probably the easiest way to summarize what we do, what I do, help out for communications.
Great. Well, thank you both. And if anybody ever has any questions about our roles or what we can do to help you, please feel free to reach out. Today, I thought we could talk about a great topic that actually, Karen, you brought up before, and I wanted to address because it is it's a common issue that I think sometimes can be overlooked when people are asking about custody issues or parenting time issues. And that topic really is, navigating a family law case when a child has special needs or a disability. And I think that is a complex issue. And I think it's a lot of the reason why you might not hear a lot of information about it in something like this, an overview of a family law case, because it is a rather complex issue, a complex custody issue. But it's really important to know a little bit more about that. So maybe you can start planning on your own or know questions or things to do when you meet with your attorney. When you think about special needs or disabilities, do either of you have, an idea about that? Or do you, think of cases maybe or questions maybe you've had about what kind of special needs or disabilities we should pay attention to?
I think for me, the specific situation that came up was around a child that was on the spectrum for autism, in terms of how that's handled. And it was a child that was kind of in the upper grades for elementary, so kind of going into middle school. So there's a transition for that, then top of the family transition, and then everything else, just understanding the support system that's often required for that. And then when you go through a legal process, kind of where that would be required, or how that, if that needs to change, and have those discussions. That's where that kind of came from.
Yeah, definitely. We're seeing a lot more cases with children on the spectrum. We see a lot of dual diagnosis cases where a child might have a diagnosis or be on the spectrum, and they might also have perhaps physical disabilities, or they might have other chronic or long-term disabilities that need to be considered when we are trying to determine what is in that child's best interest. And how does that family move forward? And how are we able to write a parenting plan that adequately addresses the needs of that child? So I think we are often seeing both mental disabilities, physical disabilities, and a lot of times they can be together. And so some of the complexities that arise in a family law case concern your issues of financial support, decision-making, visitation, and even property distribution if you're still in the divorce process. But one thing to really pay attention to if you have a child with special needs or disabilities is child support and financial contributions. I hear a lot from clients that child support is not enough to care for a child with special needs. And that's true. I think child support is primarily, unfortunately, a one-size-fits-all. We're just looking at parenting time and we're looking at income. Sometimes we're not necessarily looking at the expenses of the child when we're looking at child support. And so if you have a child with special needs or a disability, working with your attorney or your paralegal on what the actual expenses are for your child is going to be very important, because you will have a child support provision in your either settlement agreement or an order entered by the court, but you're also going to need provisions and agreements as to responsibility for those extra expenses that you might have. And I'm seeing extra expenses. It could be for services that might be out of network. It could be for specific equipment that is needed for a child. It could be for nutritional needs for a child. For instance, special foods, special supplements or vitamins, all of those things that might not be covered by insurance, but are definitely needed or recommended by a provider. And so child support's most likely not going to cover that. And in your case, you definitely need to bring up those extra expenses that need to be addressed outside of your child support contributions. And Tyler, you work a lot on financial affidavits. Would you say that special care needs to be taken for, children's expenses in that sense?
I do. The financial affidavit is, like you said, with child support, it's kind of one size fits all. The law is such that, and the courts are such that, they're trying to fit a lot into a little. And, if you're not taking into account kind of everything that, goes into supporting a child with disabilities, it can be missed. And while it's true that, child support and everything is modifiable, it is better to, know going in to a settlement and to a case, what exactly all those expenses can come out to. The financial affidavit itself, it has some spaces for, to list things, but it doesn't point it out, so it can be easily overlooked, especially with the pressures of, your life changing and, going through the divorce process or the separation process, so a lot of those things can be easily overlooked.
And they could also be in somebody's credit card statements. They might just be thinking, I'm listing out all of my debt because maybe I am using my credit card for all these expenses. And then they're not actually itemizing what those expenses are for us to use when we're looking at financial support for the children. But one thing they can do, and I think is helpful, come up with a supplementary list of all of the expenses for your child, because the Illinois affidavit form is not going to highlight that. You might just want to make your own list and let us know that you're sending an additional attachment that specifies all of those expenses that need to be addressed for your child.
Yep.
And I think that's also a good segue into expenses for your child aren't going to just be while your child is a minor. Oftentimes, special needs or disabilities, that's going to be chronic or a lifelong situation. And in Illinois, you can have child support or financial obligations extend past the year of 18 or graduation from high school for certain special needs and disabilities. There is actually a provision in the statute that allows for a continuation of financial support for an adult child that has a disability. And so it's really important, like Tyler said, at the start of your case to really itemize and set up what the expenses are and to understand what the special needs or disability is, because very well, we may need to monitor that or make sure that the court realizes that jurisdiction will continue when the child is also an adult, because we still need financial assistance and help for the disability.
That's a great point. Just, I don't think a lot of people know that, and that is, kind of a big thing. So it's a good point to point out for everybody.
And, one way that you can help your attorney help you and be very successful in determining what there needs to be through decision-making, medical care, educational care, visitation, or your overnights and parenting time is to sit down with your attorney and go through a day in the life. Go through an actual day in the life of you and your child, so that, again, your attorney can help advocate for you about the needs of your child, so that we are representing a parenting plan that makes sure that your child can handle that, make sure the co-parent can handle that. And that day in the life is going to be really valuable. If through negotiations, you are unable to get the other parent to understand the specific needs of your child, then we have to prepare and show the court. And so just taking time, maybe perhaps sitting down on a day where you can map out what does your day look like from the time that your child wakes up until the time your child needs to go to bed, what that looks like, and give that to your attorney. That is, I think, the biggest tip that you can have when you're starting to work with your attorney, or when you're starting to realize that maybe you can't make certain decisions with your co-parent and you need that advocate to help you come up with a plan that's appropriate for your child. Yeah. So there's a lot of complexities when you have a child with special needs or a disability. Your financial support, your, again, decision-making for medical, your providers. Sometimes you have providers that aren't covered by insurance. We have to make sure that both parents are all at least on the same page, whether that is by agreement or that the court is supportive of what you need to do for your child, and you can obtain an order to help yourselves and your child, but there's complexities there. So 2 takeaways: make sure you know what those expenses are, share them with your attorney. Make sure you go through and you clearly identify a day in the life. And I think then you're on a really good path for having an order that represents the best interest of your child.
Yeah, makes sense.
So anything else about that topic, or do you guys have any questions that you think would be helpful for our listeners that we can address today?
I don't.
No, I think that covers what came up for what came up through our office. Thank you.
Okay, well, thank you for that topic. It's a really good topic. I clearly didn't go into it too in depth, but hopefully with some of that preparation and takeaways, it can help you really start dealing with the complexities of that situation. Well, maybe we could talk a little bit about some common questions that we've been receiving so that our listeners can benefit from that. The first one's a financial one. So Tyler, I'm going to look to you again. Maybe you don't mind answering this.
Sure.
But we often get a question about what is a retainer.
Yes. What is a retainer? Sure. A retainer in our profession is, it's basically an agreement between you, Aaron, and the client for future work, compensation for future work. And, you sit down with clients in planning sessions and kind of walk through what you think their situation looks like, and come up with, what an initial retainer would be, and that retainer can vary depending on the complexities of the case. But, the retainer itself is a payment at the beginning of the case. The retainer can be replenished over the course of the case, given evolving circumstances within the case. But and like I said, it's an agreement for compensation, with the attorney. Retainers a couple of things retainers are not. They are not the amount of the case. You know, retainers are, you know, specifically, you know, given to start a case. You know, when we start a case at the firm, there is a lot that goes into opening up a case file. You know, and part of those, that initial retainer payment, you know, goes to opening a case. You know, there's a lot that goes into it from Karen's end, from my end, and obviously Aaron on your end. You know, and so with that, and throughout the case, generally when we bill, we bill on a monthly basis, and Aaron and we all keep track of our time that we work on cases. And at the end of the month, you know, bills are sent out, and your invoice, the client's invoice that they receive, will reflect, you know, a detailed breakdown of all the services provided over the month, and then we bill against the retainer, you know, and then, you know, funds are taken out of the retainer account and, you know, used to pay for the services provided. Another thing, retainers are not ours. We are not allowed to use the retainers until services are rendered. And we define that as when an invoice is issued to the client, you know, as being services rendered. We are not free to, they go into a special account called an 𝗍𝗲𝗋 account. We're not free to use those funds for any reason until, you know, such time that services are rendered via monthly bill. If throughout the case there is, you know, the case is moving along and, you know, more services are provided, you know, we will ask, you know, throughout the case that maybe the client replenish the retainer account. Again, that replenishment is not, you know, service provided. That's just, you know, the agreement for future services. So it's the same process repeats itself. We keep track of all of our time and provide detailed statements to the clients on a monthly basis, you know, and then bill against those retainer accounts.
And I think a follow-up question can be, why a retainer? And I think it's specific to the type of law. You will see out there a lot of people offer flat fees. We offer a flat fee if you're coming from mediation or another trusted divorce professional, financial professional, somebody that's assisting you with narrowing your issues. But it does depend on the type of law, whether it's a retainer or a flat fee. And typically you will see in family law cases that a lot of attorneys use the retainer system. And I think one of the reasons why we do that is because it's family law and it can be unpredictable. There's many things that influence a family law case. There are emotions, there are financial stressors, there are just interpersonal problems. And your case, while you might hope that it will be relatively smooth, and we all hope that it will be relatively smooth, your changes might change immediately. And a retainer system allows your attorney to adapt to any of those changes and provide you with services rather than saying, oh, well, that's not part of our service agreement. Let's discuss that, what that extra cost is going to be to work with the school, to work with a guardian ad litem, to work with another provider. The retainer is there so that we can meet your needs as your case needs it. And then going back to that flat fee again, usually flat fees, I would say in family law cases, are for cases where it's more document production and there aren't significant issues. Both parties are ready to be divorced. We don't have one party that perhaps emotionally is either angry or grieving or upset about the divorce. And we don't have children perhaps with special considerations or needing additional professionals. So a retainer allows a family law attorney to quickly and seamlessly work on the issues as they come up. And in most divorces, unfortunately, there are changes and issues from the time you decided to divorce to the time the other party learns there's an attorney involved. Things can change quickly in family law. So a retainer can really help with that process. Okay. Another question that we're getting is, it's more of a team member question, but who should I call or who should I leave a message for to get updates for my case? And Karen, you probably get questions like that, or at least might get a lot of messages saying, I have questions, I don't know who to contact. Maybe you can answer this one.
That is correct and welcomed. So that I understand that's part of what I'm here for, and to help get you into the right person for what we do. So typically, what I would normally do is say, hey, when someone calls in and leaves a message like that, I want an update. I first call the client back and I kind of qualify that. Is this around billing? So that would be with Tyler, or is this around your specific matter, like activities with the court, or getting prepared for maybe that next activity, just so we can make sure you're plugged into the right person and the right conversation takes place. And sometimes the conversation takes place with both of you. Like if there's something you want to, especially in closing a matter, when things are getting ready to close, documents are in the final stages, you both meet with them and able to do that as well. So that's typically how we approach that, to make sure there's no frustration in talking to the wrong person or feel like you're being switched around unnecessarily.
Yeah, and if you ever have a question of, who should I direct this to? Give us a call, send us a message. We field those questions all the time because we know it can be confusing. And we're all here to help you. And Karen will be able to assess and direct you in the right way if she can't answer the question herself.
Yep. Glad to help.
Okay. Great. Well, thank you, Karen. And then the last question we'll take for today concerns a topic we actually discussed at our last complimentary gathering, Zoom meetings and Zoom court. And so a question that comes up is, what do I wear for Zoom court?
Yeah.
And I think that it's something that is particular to each person. There's not just one answer. But the main thing is to show respect to the court. And so it is a different type of Zoom meeting than you're having with coworkers, friends, family. It is still as if you are in court. And so you should be dressed appropriately for showing respect to that court. If you have a job where you wear a suit, you can wear a suit to Zoom court. You might see your attorneys are still wearing their suits to Zoom court. But if that is not something that's customarily, your type of attire, just something that shows a little bit of respect, maybe a collared shirt, maybe a sweater, maybe something that could be considered either business casual or something you might wear to church or something you might wear to a special event. But it's just showing the court that you took the time to realize the importance of that Zoom meeting, and that you are not showing up in attire that suggests that you're not taking it seriously. For instance, when you join Zoom court, a lot of times there will be a disclaimer that hats are not allowed, hoodies are not allowed. You should not be eating, drinking, smoking, driving. You should be, in a room, private room, showing respect for the court's time and dressing appropriately, because it's as if you're in the courtroom. Okay, so, oh, go ahead. I heard somebody.
Oh, no, I was just agreeing with you. I think that it's important to remember that to treat it as if you're in the courtroom. And, the showing respect to the court is great, but you want to, I think it's also beneficial to present yourself, in the best way for that the court sees you. The court sees a lot of people every day, and first impressions, are, I think, judges are people, courts are made up of people, and it's important to, put your best foot forward and show the respect that, the court is showing you with your time.
I agree. Well put. Thank you, Tyler. Okay, well, does anybody have any other questions to cover today or any other comments as we close today's complimentary gathering?
No, I
None
don't
right
think so.
now.
Okay, well, to anybody listening, if you have any questions that you would like us to cover at future sessions, please feel free to visit our website at birtlaw.com and fill out our contact form. You can also call us at 630-891-2478 and let us know that you have either a question for the next complimentary gathering or you would like to attend. We will then send you the Zoom details as well as details for how to maintain your privacy to attend this meeting. So thank you so much for joining us. I hope that the tips about special needs and disability and the retainer and how to get updates on your case and how to dress for Zoom court were helpful for you today. We'll see you next week.
Thank you.
Thanks. Bye-bye.